Today we are talking about alternative dispute resolution in chapter 2 of the textbook. And there are three basic ways to get resolution on a dispute, and those are negotiation, mediation, and arbitration. And we're going to go over all three of those today. So for negotiation, this is typically the least involved and least formal of the three of them. That's just people getting together and discussing whether or not they can come up with some kind of a solution. So for the negotiation, it can be either dyadic or group, two people or more than two people. That's all that means. So if you have a business dispute and it's one person against another person, that's two people. If there's a group involved, then there's a group involved. Relational goals or outcome goals. Relational goals are those that, here's a surprise, involve relationships. I've seen a lot of negotiation on like child care cases where, or where the father doesn't want to pay and the mother says you've got to pay and that kind of stuff. And there's a negotiation usually. Outcome goals are more solution-based. This is what we're going for. So that's kind of the difference between there. And then zero-sum negotiations or win-win. So with zero-sum negotiation, basically what that is saying is that one person wins and the other person loses. There's only so big of a pie, and if one person gets 60%, the other person has to get 40% because you can't. That's just the way the pie is. On a win-win, that means that there's no kind of pie involved. Everybody can come up with a solution. And it really depends on what you're negotiating as to how you're going to kind of get those negotiations going. So your book talks about some negotiation styles, and I'm really not going to spend a lot of time on these. I have them listed. Forcing is if the party has a high concern for itself and a low concern for someone else. In other words, it's my way or the highway. Collaborating is if the party has a high concern for both itself and the other person. So the person has a concern for himself and for the other person. Usually you see this again in child custody fights. They're going to try to collaborate so it doesn't hurt the child. Compromising, when the parties share some concerns for both themselves and the other party. It's not high, it's not low, but they share basically the same kind of concern. Avoiding is when a party has low concern for itself and for the other party. Basically, I don't even see the need for mediation. Why are we here? That kind of thing. And yielding is when a party has low self-concern for itself and high for the other party. And they're more likely to give their ground to the other party if they don't really care what happens to them and cares a lot about what happens to the other person. So those are really kind of the very bare bones of negotiation. And I think we've all tried to negotiate. I kind of wonder sometimes, where do you want to go for dinner? That is like a negotiation. Well, I don't feel like pizza. Well, we had subs last week. That's the kind of negotiation that we're talking about. So in mediation, this typically gets a little more formal. There is a neutral third party to help to try to settle the dispute. So the benefits to mediation are that, it's less expensive than litigation. It maintains confidentiality. So once you go to court, those court proceedings are a matter of public record. So if you don't want all of your business blasted all over the court and the news, then mediation is maybe a way you want to go. The mediator is a trained professional, and maybe they can see a solution that neither party could have seen. So they may be able to come up with something creative that you hadn't even thought about. And the last benefit for mediation is that once you go to court, you lose control. What the other lawyer does, what your lawyer, you have some control over what the lawyer does. You have no control over what the judge does. So in mediation, you still have some control. You can still say yes or no. I have actually been through mediation. Well, I've been with a friend that went through mediation. And there was not a settlement reached, but we did go through all the steps in the mediation. The mediator said the opening statement. Each person that was involved in the mediation said their part. They had their opening statement. Then there was a joint discussion between all of the parties. What do you want? What do you want? What do you think is fair? Well, that's not fair. And then the mediator talked to all the parties in private. Each party got to talk to the mediator without anybody else around. And then you come back together, and the mediator may say, well, you know, I've talked to each of you individually, and you're not so far apart. Let's think about, and then you talk and you do some more negotiation. And then if you reach a decision, you do the closure. Now, mediation doesn't mean that you're going to reach a decision. The mediation that I went through, there was no decision made. And so the next step is going to be arbitration. And so non-binding arbitration, which we will go over that in a second. But with mediation, you're hoping that a third party can see some way for you all to come together and reach some kind of conclusion. And there are lots of benefits to mediation. Obviously, cost is a thing. When you have to hire an attorney and go to court and all of that, that gets very expensive. So the last thing that we're going to talk about for alternative dispute resolution is something called arbitration. Arbitration is the most formal of the three. There's a couple of things to remember. There is voluntary or involuntary arbitration. Arbitration uses a third person, just like mediation, a neutral third person. But in arbitration, this neutral third person is finding a solution. Whereas in mediation, you're basically working towards a solution among the parties. In arbitration, it's almost like the arbitrator is a judge, but not really. But they kind of act a little bit like a judge in that they'll listen to both sides, they'll talk, they'll try to figure out what's going on, and they'll make a decision. Now, involuntary arbitration, like in the state of North Carolina, if you have before you go to court on some things, you actually have to go through mediation and arbitration before it can go to court. Binding and non-binding is a very important aspect of arbitration. And it's just like it seems. Binding arbitration means that you will do what the arbiter said you're going to do. Non-binding means that, hey, I don't agree with that. I'm going to take it up to a court case. Arbitration is kind of like the last step before you go to court. So voluntary or involuntary, binding or non-binding. And the last thing that I want to talk about with arbitration is there's something called forced arbitration clauses. And this happens a lot more than what you realize. This is, a lot of companies use this. So if you have a dispute with them, you've agreed, like if you sign on the dotted line and you don't read everything, you've agreed to what's called forced arbitration. And that means that you have to go through binding, involuntary arbitration. You cannot sue that company. And there's a lot of consumer advocates that are upset about forced arbitration clauses because it means that you can't sue somebody even in a class action suit. So I know that there has been talk about trying to do away with forced arbitration clauses. I don't know if they're still in North Carolina or not, but it's something to be aware of when you start signing contracts to see if there's a forced arbitration clause in that contract, because that means you're giving up your right to a lawsuit and you're agreeing to go to arbitration. Arbitration may go your way, it may not. It's not as formal as court, but it's a neutral third party that's going to settle that dispute. So you might want to think about that. So if you have questions, let me know. Those are the 3 ways of alternative dispute resolution: negotiation, mediation, and arbitration. I encourage you to read your textbook because it does a good job with all of those. Thanks.